There's a comment on the piece that I did about Prince Harry, which appeared and then suddenly disappeared, which I'm rather sorry about, suggesting that are we contributing to Prince Harry's legal bills? And the answer is we are not. The legal bills that Prince Harry undoubtedly faces are not the issue that I'm concerned about. What I'm concerned about is not whether we should be clubbing in to help him. I think maybe we should. But if something is right, then something needs to be pursued. But those legal bills shouldn't be there in the first place. The legal system is out of control. It was out of control in the 19th century. It's not really been put back in control. The legal fees in the UK are quite simply a scourge upon justice. Exorbitant costs compounded by delays. These echo Charles Dickens' critique of the legal system, his criticisms, where the legal system is more preoccupied with its own self-importance and serving its purpose. In Bleak House, he masterfully captures the labyrinthine inefficiencies of the Chancery in the case of Jarndyce and Jarndyce, where no man alive knows what it means. And astonishing, the parallels between Victorian bureaucracy and modern legal practice remain starkly intact. The 1990s civil procedure reforms intended to streamline case management instead have added layers of procedural intricacy, creating fertile ground for spiralling costs. The digital age brought email and electronic records, generating a deluge of material to process and duplicating that material, because everything that's in email or on the internet needs to be printed out and filed, and the legal analysis of such immense data sets demands both time and expertise and drives up time, drives up fees. And the 6-minute unit, time recording where every activity, even a 20-second phone call, is rounded up to 6 minutes, grossly inflates bills. Dickens' caricature of self-serving lawyers resonates here as modern firms impose profit-maximizing billing targets, incentivizing bill padding and inefficiency. And who are these people, these lawyers? They're simply people who have been trained to use their memories. There's very little skill in lawyering, frankly. It's about a memory game. Justice delayed is justice denied, yet delays are endemic in the British system. Dickens' depiction of the Circumlocution Office in Little Dorrit, an institution built on how not to do it, mirrors today's court backlog. Cases can languish for years with adjournments, procedural wrangling, overloaded courts, prolonging disputes. These delays inflate costs further, leaving litigants, much like Mr. Pickwick in the Pickwick Papers, financially and emotionally drained. Recent fee hikes, some as high as 620%, exacerbate these issues. For individuals like Amanda Hicks, a social worker seeking redress against a dishonest associate, court costs outweigh the value of their claim. Even a victorious litigant like Hugh Grant may find judgment unenforceable, with defendants disappearing into a web of evasions, rendering justice like an expensive illusion. Dickens skewered the legal profession's self-interest and inefficiency and hypocrisy with incisive satire, which is as relevant today as it was in the 19th century. In Bleak House, legal costs consumed the very inheritance they were meant to protect. In Great Expectations, Wemmick's compartmentalized existence highlights the dehumanizing bureaucracy of law. Modern parallels are depressingly familiar. Legal professionals prioritize profit over resolution, while procedural bloat consumes resources. The unintended consequence is a system inaccessible to ordinary people, leaving justice available only to the insured or the absurdly wealthy. We need to reform fee structures. We need to abolish the 6-minute unit. We need to introduce flat fees for routine tasks to mitigate cost inflation. We need to put lawyers in their place. They are there to serve the public, not to serve themselves. It's not some sort of onanistic facility. though it often becomes so. Reducing delays requires funding additional judges and modernising systems, not simply shifting costs to litigants. Alternative dispute resolution needs to be encouraged. Mechanisms need to be put in place, like mediation, that could offer affordable, timely alternatives. And the persistence of Dickensian criticism in today's legal system reflects a failure, an absolute failure, to prioritise justice over bureaucracy and profit. As Dickens said, the one great principle of English law is to make business for itself. Until that principle is overturned, legal costs and delays will remain a barrier to justice for most people. And perhaps like Jarndyce and Jarndyce, the legal profession thrives on the paradox of its own inefficiency, and that must be wrong.